place your left hand on the Bible and raise your right hand. Do you swear or affirm the testimony given in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
All right, ma'am.
May it please the court, your honor, before is Mr. Nathaniel Ross. He is here on case numbers 2025 G845 0016 and 0017 on the charges of assault and battery 3rd degree and assault and battery 2nd degree. He is represented by Attorney Virgil Bard of Winsburg County Public Defender's Office. He is here to plead guilty this morning to 2 counts of assault and battery in the 3rd degree, time served in regards to those sentences. He has been detained at the Winsburg County Detention Center since November 1st of 2024. And your honor, following that plea, we also have a matter to discuss in regards to his bond. When these offenses occurred, he was out on bond in regards to a 2021 case, a criminal sexual conduct 1st degree and a burglary 1st degree matter. We previously filed the paperwork for a rule to show cause because Mr. Ross had taken off his ankle monitor.
I never did take them.
So we're doing these pleas today, right?
Yes, sir.
And then we're gonna switch over and talk about the bond situation?
That is correct, Your Honor.
Is that right, Mr.?
That's my understanding, Judge.
And on these 2 pleas, the sentence recommended is time served, is that right?
That is correct, Your Honor.
Is that right, Mr. Ross?
Yes, sir, Your Honor.
So first of all, you're going to offer guilty pleas on the assault and battery charge, 2nd and 3rd degree, or 3rd and 3rd, no?
Yes, sir. 2 counts.
Census sheet says 3rd, so.
We are reducing the assault battery 2nd to assault battery 3rd.
Right. Understand that, Mr. Ross?
Yes, sir.
How do you plead on these 2 charges?
Guilty, sir.
Mr. Ross, are you satisfied with your lawyer's services?
Yes, sir.
Has Mr. Barr done everything you've asked him to do?
Yes, Your Honor.
Any complaints about Mr. Barr?
No, sir.
You have 10 days to appeal today from a guilty plea and the sentence of it. And is he on probation now?
Who stated that she was assaulted by the subject, Mr. Nathaniel Ross. She stated that she was in a vehicle with a couple of friends and Mr. Ross was offered a ride. When Mr. Ross was boarding the vehicle, he became very angry because he wanted to sit in a specific seat. That he should just accept a free ride and sit wherever there was space. An argument ensued between the two, and Mr. Ross had a hollow pole and threw it at her, striking her left forearm just below her elbow. Your Honor, in regards to victim contact, we have reached out to Ms. numerous times over the past 2 weeks, and we have not been able to make contact with her in regards to being present in court. In regards to the 2nd assault and battery 3rd degree case, back on April 6th of 2024, Winsburg County Sheriff deputies responded to Peach Street in the Hemingway area of Winsburg County in reference to a complaint. When officers arrived on the scene, they met by Ms. as well as Ms. who witnessed the incident. They stated that Nathaniel Ross ran from behind a barn which was located on the property. Officers checked behind the barn along with Hemingway Police Department, who was unable to locate him. Officers made contact that she had been struck by Mr. Ross for no reason. She stated that she ran away from him and that he struck her again, hitting her hand and face. On scene stated to Ms. Brunson that she did not want to ride home with Ross because she heard allegations in with him that have not been proven as of yet, and that he became upset, and that's when he placed the brake handle in order to strike her. We did make contact with Ms. Brunson. She had just received a new job and she is currently on her probationary period, so she was unable to attend court today, but she was notified that the assault and battery 3rd degree charge only carries up to 30 days, but she just wanted to express to the court how fearful she is of Mr. Ross. In regards to his criminal history, back in 1997, he had a resisting arrest. 1998, a criminal domestic violence 1st offense and public disorderly conduct. In 2000, a public disorderly conduct, reckless driving, and pointing and presenting of a firearm. 2003, DUI 1st offense. 2004, breach of peace. 2005, possession of cocaine, first offense. 2006, public drunkenness. 2009, simple possession of marijuana and resisting arrest. 2011, criminal domestic violence, first offense, and transportation of alcohol in a vehicle. 2012, assault and battery, third degree, resisting arrest, and breach of peace. And again, he does have that pending burglary, first degree, and criminal sexual conduct, first degree charges.
Mr. Ross, as to these two charges here today, you still would plead guilty?
Yes, Your Honor.
Did you hear what she said happened?
Yes, Your Honor.
What she told me substantially correct on these two charges?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Mr. Ball, any concerns about these two pleas?
No concerns, Your Honor, regarding these two pleas. We asked the court to consider following the recommendation from the state. These are, I believe the court heard the facts or heard the incident report. And these are kind of peculiar incidents, Judge, but Mr. Ross has desired to plead guilty, and so we would just ask the court to consider the recommendation from the state.
I do accept the pleas being factually based. Enter into freely knowing each.
Yes, sir.
Mr. Ball, you agree?
Yes, sir, Your Honor.
These are concurrent. And do we need any no contact orders here?
I believe would like that, Your Honor.
So she will be on which one?
She is warrant ending in 145.
Those are the sentences on this court. Concurred 88 days each time served. No contact with the victim on one ending in 145.
And I would concede that point to him. He let the ankle monitor die that he was wearing at the time in regards to these charges. He did not charge up. Extreme Monitoring Concepts tried multiple times to get him to comply with their guidelines, which he did not. During that period of time, that is when Mr. Ross was again locked up on additional charges, and he was in the detention center while the ankle monitor was off. The state is recommending that his bond be revoked. Just basically reading the incidents and the facts of these charges that he picked up, this neighboring community of Hemingway is terrified of Mr. Ross. He poses an extreme danger to those people in that neighborhood, especially to the victim in the CSC itself.
Mr. Ball?
May it please the court, Judge, if I heard it correctly, if Mr. Ross, and he's prepared to talk a little bit to the court about the ankle monitor, but if he was detained, and that's the reason or the genesis of why his monitor was off, I don't know if that can really be held, he can be held accountable as far as intentionally trying to turn it off or trying to tamper with it. If he was detained, that probably explains it. In regards to the charges that he just pled to, Judge, he pled to 2 counts of assault third, which, you know, we understand that in the criminal system there's hierarchy as far as crimes and different offenses, and assault third is the lowest level or lowest form of assault that you can plead to. And so the judge, he pled to 2 counts of assault third. As far as him being a terror to the Hemingway community, if that were true, then I would have anticipated or fully expected for those folks who were saying that he's terrorizing them to be here this morning telling you, Your Honor, about how he's terrorizing them. But in fact, what we heard was that one didn't want to be here and the other one might have had a job. I respect that. But Judge, to say that he is terrorizing the community, I don't know if anything's been demonstrated this morning that can back that point up. So Judge, we would ask for his bond to be reinstated. Now, one thing I didn't mention in his plea, Your Honor, is Mr. Ross has been caught, I don't want to say caught up, but he has been in this system because we've been waiting to play out his more serious case. We have some discovery on. There's still some things we're waiting to get back on that case. And so he's, for the most part, Your Honor, he's been living really under a microscope for probably the last 3 to 4 years.
3 or 4 years.
And that doesn't excuse what he just pled to, but I do think that it kind of can go into some of the mindset where he's been kind of living under a bubble for 3.5, 4 years. the stress of worrying about a trial, stress of waiting to see when the discovery of this information is going to come in. And for the most part, notwithstanding these 2 assault thirds, he has not been in any more trouble. And I believe he, at all times when we've had appearances where he needed to be here, he's been here. I've met with him a few times in my office, so I have no doubt that, or I have no fear that he's going to abscond or become a flight risk. And I don't believe he's a danger to the community. And so, Judge, we would ask that that he be allowed to, if he can get his bond reinstated with the bondsman, that he be allowed to go back out on his bond.
Your Honor, just to clarify a point that Attorney Barr made, this violation report was sent on September 5th of 2023. These assault charges that he pled to are in 2024. The ankle monitor was not removed in regards to him being detained on new charges that he picked up. He allowed the ankle monitor to die and not responded to extreme monitoring concepts to get the device turned back on. Furthermore, on the order that was set in bond, it stated defendant must submit and wear the GPS ankle monitor at all times and must reside at his mother's house, Ms. Betty Ross, at 712 Blackberry Road in Johnsonville, South Carolina. And as you can see on the incident report, he has been staying in the Donnelly community at 84 Donnelly Street, Hemingway, South Carolina.
I have not been staying at 84 Donnelly Street. The ankle monitor had went there. I had lost the charger to it. I had problems with my financial, keeping it up, but now I got my financial scrape to keep it on. Everything paid for. I apologize to the court. I'm not no threat to the community. I'll be there with my mother, helping my mother and my grandmother as much as I can. But if you can grant my bond back, I really appreciate you.
How long was your device off, sir?
It was off for a while, you know what I'm saying? And I was.
Don't get ahead of me now. When it was off, where were you?
I was back and forth from my mother's house, you know what I'm saying? I was trying to do little yard work and stuff.
Did you know the device was off?
Yes, sir.
That's where things don't go well for you.
Well, see, I had a problem, you know what I'm saying, finding a charger here for that, you know what I'm saying? And then I was kind of timid.
Mr. Ross, when that device went off and you knew it was off, your first call or first car ride should have been to the bonding people or whoever it is, or the monitor system to get it cranked back up. That's where you failed. And I will grant you release all out of state, sir. You need to take it seriously, sir.
Thank you, Your Honor.
Ma'am.